Hi there, I'm Carolyn Morrissey, along with my teammates Matt and Jonathan. Our video is on wills and trusts. So, first of all, what is estate planning? So, this is where wills and trusts come into play. It is the process of arranging the management and distribution of your assets after your death or if you become incapacitated. So, you're going to want to create a plan to ensure your property, finances, and personal belongings are passed on to your chosen beneficiaries. It's really important that you leave specific directions about how to properly manage your care and assets if you become incapacitated and can't make these important decisions anymore. So, your options are it can be a will. So, this is a legal document that gives specific directions to your executor. So, your executor is someone that you name to manage your estate. With a will, you have to go through a probate, which is a legal process where the court has to officially permit your named executor to begin distributing your assets, which can take a long time. A will has provisions for assets with specific beneficiaries and those without. So, for example, your will could state that your sister gets your engagement ring, but all other assets in your estate without a named beneficiary should be equally divided between your brother and sister. The components that make up a will, so it needs to have an introduction with a title, which should include your testator's full legal name and state that this is their last will. It needs testator's specific information. Your executor needs to be on there, beneficiaries, as well as your testator's named guardian if they have minor children. Like I said, you need to be very specific about your asset distribution. And then you need to write that this is your new will if you've ever revoked previous wills in the past. And then lastly, to be valid, the testator must sign the will as well as two witnesses' signatures, which is usually required. For example, Wisconsin does require this. There are some limitations of a will. Like I said, it needs to go through a lengthy probate process, which can be very grueling. It becomes part of public record, which some people do not like. You can't protect your assets from creditors, and you can't avoid paying estate taxes. Now I will pass it off to Matt to discuss your other option of trusts.
All right. So now we'll move on to trusts. Trusts are essentially legal containers that hold your assets on behalf of the beneficiary. So someone that will inherit whatever assets are in the trust. Trusts are great estate planning tools as they help you avoid the probate process, empowering a trustee you name to distribute your assets according to what the trust says. The two most common types of trusts in estate planning are revocable and irrevocable living trusts. Some pros: if they're irrevocable, it can protect your assets from creditors. It can also minimize estate taxes and avoid probate court. This living trusts manage your assets if you become unable to manage them yourself. Some cons, though, is they can be a bit pricey to create and maintain, and you need legal assistance usually to establish them. Also, if it's an irrevocable trust, it may be impossible to change after you've created it. Next, transferring business assets through a trust. Grantor retained annuity trusts are estate planning instruments that allow a grantor to lock assets into a trust, which then they will earn annual income from. Grants are usually established for a specific number of years, so say 10 years. And when the trust expires, the beneficiary will receive the assets with minimal or no gift tax related. Electing small business trusts or ESBTs are taxed in a different manner from normal trusts, as the stock portion or S is the only part of the trust that is actually taxed. And it's taxed at the highest individual rate of income tax. The taxable income attribute of the S portion includes only items of income, loss, or deduction. that's attributed to the trust um, under normal corporation rules of stock. Gain or loss from its disposition of stock or S in any state or local income taxes and trust administration expenses are all added to that stock or the price that comes out of it. Capital losses are allowed only to the extent of capital gains in this case. Next is the trust for succession. First is revocable living trust. The purpose of this trust is to allow grantors to retain control of assets during their lifetime, and the assets in the trust negate probate, so you never have to go through it upon your death or whoever set the trust up. This is useful for smooth transition to heirs without court intervention. Some advantages of this are it provides privacy, again, avoids probate, and ensures flexibility as the grantor can modify or revoke the trust while they're still alive. Some limitations are since the assets are still technically in your name, the grantor is not fully protected, or the assets of the grantor are not fully protected from creditors or certain taxes. On the other hand, you have irrevocable trusts. Um, Once they're established, they usually can't be altered, which does help protect against creditors and reduce the amount of estate that can actually be taxed. This provides a more tax efficient wealth transfer. Um, as stated previously, the advantages are provides tax benefits and asset protection from creditors. And it's great to shelter assets from estate and generation skipping transfer taxes. Some limitations here are since the grantor officially lets go of control of the assets, changes are either challenging or straight up impossible to make. So careful planning when building these trusts is very important. And next is the tax considerations for wills and trusts. There are three major taxes that go into wills and trusts, and that'll be estate taxes, capital gains tax, and income tax on trusts. So estate tax is a federal tax and sometimes also a state tax, depending on the state, that is applied to the value of an estate above a set amount, which can bring down the overall amount made from selling large estates. Capital gains tax, there is a way to allow the inherited assets to have their costs adjusted in the market over time of the inheritance. So this can actually reduce the amount of capital gains tax taken out if the assets are sold. It's very important for things like family held real estate and investments. Income tax on trusts. Different types of trusts have various different taxes applied. Um, Grantor trusts can pass the income tax on to the grantor, while non-grantor trusts face usually a high income tax rate if the income is not distributed properly to the beneficiaries of the trust. And lastly, we move on to deciding between a will and trust. So there's a lot of differences between the two. When they take effect, a will, it takes effect right when you die. Well, a trust can either take effect while you're alive or when you die. Assets are managed, how assets are managed. Will specifies how to distribute assets after a beneficiary or to beneficiaries after death. Well, a trust allows you to transfer assets to a trustee and they manage the trust for you. Some flexibility. A trust provides quite a bit more flexibility than a will because it can be used to distribute assets before your death, before, during, or after your death. Privacy. A will becomes public record and it's filed with probate court, which some people don't like public records, which obviously that is a main privacy concern. When to use a will is pretty good if you don't have many assets, you aren't married, or you plan to leave everything to a spouse. But a trust, on the other hand, is great if you have a large and complex estate. Guardianship, a will can be used to name guardians for your children, any other dependents, or pets. You can also use a will and trust together to ensure there's no gaps in your estate plan. For example, if you use a pour over will to direct everything in your estate to a living trust when you die. A will is an example of a simple legal document that provides instructions on how to distribute property to beneficiaries after death. Well, a trust is a fairly complex legal contract, and this allows you to transfer your property to an account to be managed by another person. If you want to ensure there's no gaps, I would use both a will and a living trust. Creating a living trust is a good option for, again, those very complex estates with multiple properties, investment accounts, or sizable assets. And next, I will pass it on to Jonathan to continue.
So now diving deeper into wills and trusts going into the state of Wisconsin, a person who is at least 18 years old can make, amend, or revoke a will and trust. This will or trust can be challenged if there's any alleged interference. Also, a beneficiary who thinks they should be a beneficiary can also contest the validity of the trust. Both can be, wills and trusts can be used to avoid probate, but trusts are more common because of their flexibility. And whether picking a will or trust is important to meet with a planning attorney in order to have everything squared away. Now going into some cases, J. Stephen Tukalski is suing his sister, Terry Stevens, over the distribution of their parents' estate, claiming that she wrongfully obtained property that should have belonged to him. The dispute centers around a 1999 trust and will, which originally provided for the equal division of the estate among their 4 children. However, as the relationship between Stephen and his parents deteriorated, the trust was revised without Stephen's knowledge, potentially excluding him or altering his inheritance. Stephen sought a constructive trust as an equitable remedy, arguing that Terry's possessions of certain property resulted from torturous acts by other family members, Susan and James, who allegedly facilitated her wrongful acquisition of this property. The case centers around whether the revised trust is valid, whether Stephen was properly informed of the charges, and whether Terry's actions in acquiring the disputed property were unjust. If Stephen's claims are sustained in court, the court may impose a constructive trust, compelling Terry to return the property that rightfully belongs to him. Now moving on to the case in North Carolina versus Kimberly Rice. The North Carolina versus Kimberly Rice Kastner 1992 Family Trust is a U.S. Supreme Court case that addressed the constitutionality of taxing trusts based on the residency of the beneficiary. This case involved the North Carolina state tax assessment on a trust income, even though the trust's only beneficiary, Kimberly Rice Kastner, was a resident of New York and not North Carolina. The state beneficiaries lived in North Carolina for part of the tax years in question. The court, however, ruled in favor of the taxpayer, Kastner, holding that North Carolina's tax on the trust income violated the Due Process Clause of the U.S. Constitution. The decision was based on the fact that the beneficiary's connection to North Carolina was too tenuous to justify taxing the trust. The court emphasized that the trust was not administered in North Carolina and the beneficiary did not have control over the trust's income or assets. This ruling clarified that states cannot tax trusts merely because the beneficiary resides in the state unless there is a strong connection to the trust. And then finally, when seeking advice and legal guidance, when creating a will or trust, it's extremely important that you have an attorney present to make sure all your wishes will be able to be granted legally. You should keep yourself updated on changing laws. This includes real estate, bank accounts, investments, and personal property. It is best to do this in writing and in person for the process to go as smooth as possible. And then finally have review dates scheduled and make sure to make changes to your will and trust if any life changes also occur, and make sure to do these with a planning attorney. Here are our sources, and thank you for watching.